It was 1927 in McGill, Nevada. As he strolled past the open doors of the McGill Club on his way home from work, Chet Anderson furtively tilted his head toward the familiar sounds of talk and friendly laughter that came from within. Chet paused, listening intently. He could hear the dull whir of cards being shuffled, the thin click of gambling chips striking the pot in the middle of the poker table. To Chet Anderson, those sounds were irresistible. It was payday at the local mining company where Chet worked as a clerk. He was flush. Try as he might to ignore the enticements of the McGill Club, Chet knew all too well the futility of any attempt to resist. Soon he would be inside, seated at his favorite poker table. The only real question was how much of his paycheck would be left at the end of the evening. At home, Chet's wife Gladys waited anxiously for her husband's return. She knew where Chet was, of course. It was payday. He was at the McGill. How she hated that name. Chet Anderson's gambling habits had all but shattered Gladys's dreams of a happy marriage and home. For the past year, the family had barely managed to make ends meet. Their 2 children desperately needed clothes. Their rundown shack needed a new stove, and the cupboards were empty. Luxuries were out of the question for the Andersons. Gladys, however, would have been content with just the bare necessities. But Gladys wasn't about to take Chet's gambling lying down. She had met with a local attorney, C.E. Handwright, and he agreed to help her. He suggested that she bring a lawsuit against the McGill Club. The charge: that the club had unlawfully deprived Gladys Anderson of her husband's companionship and the family's only means of support. The fact that no one had ever sued a gambling hall in Nevada was no deterrent to Handwright. He prided himself on his compassion, and he was determined to help his desperate client. Lawyer Handwright was well aware of the obstacles he faced. He knew that under the laws of the time, a wife must generally live with her husband's bad habits. Making matters worse, traditionally, a husband could sue for the loss of his wife's consortium, but the wife could not. Still, thought Handwright, several states had already enacted statutes to recover money lost by a husband who gambled. Perhaps this trend would influence a Nevada court to do the same as well. Besides, it was 1927. It was time the laws were changed. And Handwright had another pistol in his arsenal, although most authorities simply looked the other way. In 1927, gambling was illegal in Nevada. There were exceptions, of course, for poker, 500, solo and whist, but only if the deal was passed from hand to hand, and only if the house took no percentage of the pot. Handwright reasoned that because the McGill Club took a percentage in violation of state law, it was engaging in criminal activity. Such illegal practice obviously constituted a public nuisance, thought Handwright. Surely, Mrs. Anderson and her children were entitled to some kind of compensation. In her cold, barren bed, Gladys Anderson heard the sounds of shuffling feet in front of the shack. Slowly the latch lifted and the footsteps of her husband approached. Without a word, he undressed and climbed into bed, the smell of whiskey wafting from him. Gladys could not bring herself to ask how much of his paycheck remained. It was the final straw. Tomorrow, she thought wryly, she would give lawyer Handwright the go-ahead to instigate his lawsuit. Within a week, the suit against the McGill Club was filed in White Pine County. The lawsuit claimed that Mrs. Anderson was entitled to recover consequential damages for injury to her marital rights, occasioned by malicious and unlawful motives on the part of the McGill Club in maintaining a nuisance to tempt diverse persons, including Chet Anderson, to frequent its place of business and engage habitually in playing draw and stud poker. The suit also stated that Mr. Anderson could not resist the temptation set before him by the McGill Club, and that deprived his wife of his companionship and caused him to lose money needed for his family's support. The results of the court case were not long in coming. The judge for White Pine County, W.H. Edwards, dismissed the case on the purely legal grounds that it failed to state a claim for relief that was recognized under Nevada law. there would be no trial to determine the merits of Gladys Anderson's complaint. But Attorney Hanwright refused to give up. He immediately filed an appeal with the Nevada Supreme Court. In his arguments before the court, Hanwright emphasized the wrongs done to his client by the McGill Club. He pointed out that the club had never openly denied that it had unlawfully operated a gambling house, that it created a public nuisance. Although he acknowledged the novelty of the lawsuit, he argued that this should not affect the judgment of the court. He urged that the McGill Club be held liable. Hanwright's arguments were countered on technical grounds by the law firm of Chandler and Quayle. It was suggested that rights as claimed by Gladys Anderson could only be granted by the Nevada legislature. Lacking such legislation, they maintained, the McGill Club could not be held responsible. Her hope for a better future hanging in the balance, Gladys Anderson waited patiently for the Supreme Court's decision. Daily she prayed that her lawsuit would be reinstated. If she could proceed to a trial, perhaps she could recover the $5,000 in damages she felt she had coming to her. But the prospect of the Supreme Court agreeing with White Pine County hung eerily over her. On May 12, 1928, a messenger arrived with a letter from Mr. Hanwright. With trembling hands, she tore open the envelope. Her heart sank. There were the words, "Very much regret," glaring out of the first sentence. The Nevada Supreme Court had affirmed Judge Edwards' decision. In its published opinion, written by Chief Justice Saunders, the Supreme Court called the lawsuit a novelty, both in form and substance. Its decision was summed up in a single sentence. "A husband is exposed to temptations, enticements, and allurements of the world," wrote the justice, "which easily withdraw him from the society of his wife, and the wife had reason to expect all of these things when she entered the marriage relation, and her right to society had all these conditions. If the court were to sustain such an action," said Judge Saunders, "then a most fruitful source of litigation would result." For Gladys Anderson, it was over. Whether or not Chet Anderson continued to gamble away his wages is unknown. Perhaps he did. Nonetheless, the state of Nevada would resolve the issue once and for all several years later. In 1931, gambling in Nevada was made legal once and for all.